Pleasant day, everyone. Our case for today is Iloilo Ice and Cold Storage Company versus Public Utility Board. The facts of the case are the following. Francisco Villanueva Jr., Secretary of the Public Utility Commission, investigated the operation of ice plants in Iloilo. He reported to the Public Utility Commission that the Iloilo Ice and Cold Storage Company should be considered a public utility. Before the Public Utility Commission, Iloilo Ice and Cold Storage Company opposed on the ground that business has been carried on with selected customers only. A notice posted in the Iloilo store reads, "No ice is sold to the public by this plant. Purchases can only be made by private contract." On appeal, the Public Utility Board affirmed the Public Utility Commission's decision, hence the present petition. The issue which the Supreme Court had to resolve was whether or not the Iloilo Ice and Cold Storage Company is a public utility. The Supreme Court held that in the negative, stating that the essential feature of a public use is that it is not confined to privileged individuals, but is open to indefinite public. The use is public if all persons have the right to use under the same circumstances. If the company sells ice to all persons seeking its service, it would be a public utility. Otherwise, if it was organized solely for particular persons under strictly private contracts and was never devoted by its owners to public use, it could not be held to be a public utility. Iloilo Ice and Cold Storage Company has been and is to remain a private enterprise. It is not a public utility within the meaning of the law.